Now, let's get into the rule. What is the rule? The rule that we're going to be talking about is the non-compete announcements. This is an FTC rule that just dropped. Now, let's start with some basics. What is the FTC? The FTC is the Federal Trade Commission. And I'm going to be very clear with you guys. And this is some of this is my opinion and some of this is just factual. Generally, I am not a huge fan of government regulation. That is my proclivity. I generally think things are bad. But this is one of those times where I say, nope, this one actually will be pretty good, because what it is doing is it is taking something that has been court precedent in most cases, and it is moving it over into administrative law, into regulation. Now, these agencies, Federal Trade Commission, they're given power by Congress. And once they're given power by Congress to do very specific things, right? Federal Trade Commission, well, you can imagine it has to do with trade. The other federal administrations that generally have similar roles are places like OSHA, the Occupational Safety and Health Administration, that also issues workplace or general business related regulation. So FTC, OSHA, definitely up in your business when it comes to work. So these rules are the same as if they were passed by Congress or let's say court precedent, except for now they apply all across the United States. You can have a court case that might only be binding in one state. It might only be binding in one judicial district. It might only be binding in part of the country, unless it's ruled on by the Supreme Court. But when you have the FTC come out and promulgate a rule, it applies to all of the United States and all of the people there. Now, I saw somebody mentioning this in the chat. Does this apply to Canadians? Well, probably not. Okay, so this is only going to impact Americans and people who are in America, working in America. And so what this impact will be is chiefly going to be impacting the people who are working in America, so American VTubers. So for example, we talked about Sayu, and in fact, she's one of the folks that they were trying to get to sign this extra agreement, this silencing contract, for example, if you remember that. She's American, right? So, for example, this would apply to her. So if she was to sign with another agency, they could not enforce a non-compete against her. Now, let's start with this. FTC announces rule banning non-competes. What is a non-compete? A non-compete agreement is an agreement not to do similar type work for a given period of time. So once again, a non-compete is an agreement not to do similar types of work for a period of time. So let's say you're an oil rig worker and you work on oil rigs. The non-compete might say, do not work on another oil rig for 6 months, 1 year, 3 years. Now, generally, the law and courts do not like this. So under the FTC's new rule, existing non-competes for the vast majority of workers will no longer be enforceable after the rule's effective date. So the existing non-competes are not going to be able to be effective. So continuing here, these are going to be non-enforceable. So if you today already have a non-compete, it is not enforceable. Because understand how a non-compete clause works. A non-compete clause works when they enforce it against you. So now, as of date, it's unenforceable. So take your contract and take a big red highlighter and just strike it through that. They can no longer enforce that against you. So it's unenforceable. So even if you have an existing contract, it is not enforceable unless, and there is one exception here, and that is for senior executives who are a very small number. They have to make over a certain amount of money, and they can remain in force for a limited period of time if they're existing non-competes. But for everybody else, they're all null and void. Right? Employers will be required to provide notice to workers who are bound by an existing non-compete that they will no longer be enforcing any non-competes. Guys, if you're a worker and you get one of these, please, please, please allow this out there. Let me see your, send me, sorry, you need to put it out there. With your non-compete. I want to see those letters from your companies. I want to see all this stuff they send out. I'm really interested to see this. These letters that go out and say your non-compete is now unenforceable. In January, it proposed its final rule, which was subject to 90-day public comment. They received 26,000 comments, with 25,000 comments in support of the rule. So the FTC went through that, reviewed the comments, and in the final rule, they determined it is an unfair method of competition, and therefore in violation of Section 5 of the FTC Act for employers to enter into non-competes with workers and enforce certain non-competes. This is what courts have largely found when they look at non-competes. They've largely thrown them out. So this is kind of aligning the national regulation with law. The commission found that non-competes tend to negatively affect competitive conditions in labor markets by inhibiting efficient matching between workers and employers. It also found that non-competes tend to negatively affect competitive conditions in product and service markets, inhibiting new business formation and innovation. There's also evidence that non-competes lead to increased market concentration and higher prices for consumers. So alternatives. So here we go, guys. This is what they're going to use against folks. They're going to have trade secret laws and NDAs to protect proprietary and sensitive information. 95% of workers with a non-compete have an NDA. So instead of using non-competes to lock in workers, they wish to retain workers that can compete on the merits for the workers' labor services by improving wages and working conditions. So what they can do is this too. They can also use financial incentives in order to lure people to stay longer. So I think that is perfectly fine. If they say, okay, you stay a year, you get a bonus. You stay 2 years, you get a bonus, right, for longevity. They can do that, right? They can incentivize you positively. They just can't say you can't compete. Also, what they are going to do is have NDAs. And remember, V&U, Niji Sanji, these black corporations over there in Asia, they have NDAs. They don't have non-competes, but they do have NDAs. So this is a big thing for them to still be able to have an NDA, because most of the time what they care about is the information that gets out. The information that gets out. So that's what, like, 9 times out of 10 they're caring about. And they've got these things in there. They've also got provisions like duties of confidentiality. If you guys want to see, let's pull up the Niji Sanji contract real quick, because I missed the Niji Sanji contract. I like it so much. I like it long time. The Niji Sanji contract here has a article on confidentiality. It's Article 21, right? So that is still going to be something that's around, right, in the loathsome contracts with these black corporations. But they won't be able to say you can't join another company. So they can say you keep our information secret, and that's how they're going to gag VTubers. So for all of those that think that the Niji Sanji talent is going to be able to come out here and talk about Niji Sanji and all that, well, they're still under NDA, and that's not gone away, right? That's not gone away. Let's see here. Well, actually, let's finish this article. We're almost done here. It's just a little bit left. Okay. So Under the final rule, existing non-competes for senior executives remain in full force. However, employers are prohibited from new non-competes with senior executives. A senior executive is a worker making more than $151,000 who is in a policy-making position. Additionally, the commission has eliminated a provision in the proposed rule that would have required employers to legally modify existing non-competes by formally rescinding them. This change will help streamline compliance. They will simply provide notice that it's not enforced in the future, which is fine. This is actually smart. To aid in compliance, the commission has included model language in the final rule that employers can use to communicate to workers. So look for some very generic language to go out. In fact, let's look at that. Let's look at that language here. The commission vote to approve was 3-2. So the final rule will become effective 120 days after publication in the Federal Register. I believe it was just published. So yeah, it's got some time. So it'll be effective quite soon. Once the rule is effective, market participants can report information on a suspected violation to the Bureau of Competition. So guys, ladies and gentlemen, when you guys are asking me, what can we do to help fight against these corporations? Here's what we can do. Every single time we see a VTuber corporation that is going and operating in America or with American VTubers, we can report them to this address, to non-compete@ftc.gov. If we find out that they are violating that, any VTuber agency that is coming in and hiring American employees, American VTubers, whether they try to consider them independent contractors or not, it actually doesn't matter. That's going to be nullified by this. You could report them to this and say, hey, look, these guys are in the market, and maybe get more regulation of that industry, right? Which I think will ultimately be a good thing, All right, so that's the rule itself. There's a little bit of language here. Let me see if we can find this proposed language. Okay, so here's the notice. I'm going to open up the notice in English, because this is a notice that you should be getting from your employer in English. Let's see if this thing opens up properly. If my Libre writer is gonna deal with this. Okay, let me show you this. So here's what it will look like. So a new rule. This is a new rule enforced by the FTC, makes it unlawful for us to enforce a non-compete. As of date, employer chooses, but no longer than the effective date of the final rule, employer name will not enforce any non-compete clause against you. This means that as of date, employer chooses, but no later than the effective date of the final rule, you may seek or accept a job with any company or any person, even if they compete with your employer. You may run your own business, even if it competes with X. You may compete with X following your employment with X. The FTC's new rule does not affect any other terms or conditions of your employment. And they have translations in English, Spanish, Chinese, Arabic, Vietnamese, Tagalog, and Korean. So you've got all of the cool languages dropped there. So yeah, big stuff there. That's going to be a big one for stopping those buraco companies. Also, real quick, shout out to Horse Girls, because I do indeed love my Horse Girls. Rima was on top of this. Rima dropped this into X, so I just want to give her a little love, because I like supporting people doing good stuff. So here you go. She just dropped all the facts here that they non-competes are widely used. They affect a lot of workers in the United States. That they're not going to be able to enter into agreements, and that they're going to use non-competes and trade secret to keep people silent, which is going to be true in the VTuber sphere as well.